So Zach or Josh, if someone has a question, I'm not noticing it, if you want to flag me down, just, interrupt and let me know.
Sounds good.
So the key things that I'm going to go over are kind of this laundry list of things regarding the timeline, who's a covered employer, what makes an employee eligible, what types of leave would be qualifying, how do you coordinate the paid leave Oregon benefits with other types of leave, what the contribution requirements are going to be, what the special provisions are for small employers, what an equivalent plan is, and we'll talk about why that matters. Notice requirements that the employer has to give, as well as what the employee has to give, and then employee protections that attach to time off taken in conjunction with this law. So here's some key dates on the implementation timeline. I don't know if any of you have CBAs that govern your workforce, but if you do, the collective bargaining agreement that was negotiated prior to September 29, 2019 does not need to be reopened before the expiration date to account for the paid leave insurance program. Anything after would have to be negotiated. The Oregon Employment Department is in charge of this program because this is really an insurance program. It's a lot like unemployment insurance. And so OED was the lucky agency that inherited this one. I think there was a little bit of a not me among the different agencies that might have taken control over it. And OED drew the short straw. They are scheduled to have the regulations finalized by September 1. And so again, that would be a good point to check back to make sure that, whatever your questions are, looking at them in the fall, that everything is lining up with what we anticipated seeing. January 1, 2023 will be the beginning of when contributions have to be made to the trust fund. Employers will be needing to provide employees with a notice of rights. The OED is preparing a model policy so that, again, that's going to be similar kind of thing as a poster that's going to have to go up with all of your other employment posters. And there may be other notice requirements of like when and where that notice needs to be provided. There will be protections against discrimination and retaliation beginning as early as January 1, 2023. So kind of take note of that. And then employers must begin maintaining payroll records of contributions beginning January 1. I included this August 3 notice requirement for employees, and we'll see later that if an employee has a need for foreseeable leave that will be covered by Paid Leave Oregon, they do have an obligation to be providing the employer with at least 30 days notice. And so since the employees can actually begin applying and receiving benefits and using the protected time off beginning September 3rd, the 30 days prior to that would be August 3rd that the employees would have to start giving notice if they needed that leave to start right away. Let's talk a little bit about covered employers and eligible employees. Basically, everyone's a covered employer. This is where I think a lot of employers have heartburn, especially if they were not traditionally covered by OFLA or FEMLA, so Oregon Family Leave and the Federal Family Medical Leave Act, that have employee thresholds of 25 and 50 respectively. So those smaller employers under 25 are now scrambling because they're now covered by this provision and pretty unfamiliar with how to deal with this kind of protected leave. Who is not covered is the federal government and tribal governments, although tribal governments do have the opportunity to opt in. Similarly, self-employed business owners have the opportunity to opt in, as do independent contractors. But pretty much all Oregon employers are otherwise covered. Eligible employee really is based on a minimum number of earnings and whether they've been making contributions into the trust during the prior base year or alternative base year. And then they have to have experience a qualifying event and submit an application for benefits. They cannot be receiving workers' compensation benefits or unemployment insurance benefits during the same time period that they're claiming Paid Leave Oregon benefits. That would be the disqualifier. So what this really means is that employers can have a brand new employee who just started, and they may be eligible to be able to take the paid leave benefits because there is no minimum number of days that someone needs to be employed to be able to access the benefits if they're otherwise eligible. So that's a super fun one for employers. And it's going to be definitely something that's going to take some getting used to. Who is not covered? Again, employees of the federal government, employees of tribal governments, unless the tribal government has opted in to participate. People who are self-employed or independent contractors, unless they have chosen to participate. Employees that only work outside of Oregon. I mean, since COVID, the number of remote workers, especially out of state, has really increased. And so this is one area where there's a lot of questions about. And then certainly for if you have an employee that's only working outside of Oregon, even if they're reporting here to Oregon, they are not an eligible employee for benefits. But you'll see later that when we're counting how many employees you have to figure out whether you're a small employer or not, those employees actually still count. So there's a lot of different things that these remote workers are going to be covered by or not covered by. Qualifying reasons for leave really kind of summarize this in terms of, family leave, which includes both parental leave and to care for a family member with a serious health condition. And then medical leave, which is for the employee's own serious health condition. And then what we call safe leave, which is the traditional leave that we've seen for a number of years under this statute that's listed in here regarding those who need to seek medical, legal, or law enforcement assistance or other types of safe assistance due to domestic violence, sexual assault, stalking, or harassment. So those are the only things that are covered by this program in terms of an employee has a need for time off. It would only be these that are qualifying them for this paid insurance benefit. Note that when we talk about taking that serious health condition leave to care for a family member, the Paid Leave Oregon program has an expanded definition of family member. Many of you already familiar with FEMLA and OFLA know that OFLA has an expanded definition over FEMLA, and now this has even a broader definition than even OFLA does. And so while it's traditional family members such as parents and children, OFLA adds in grandparents and grandchildren, but then this adds in also spouses or domestic partners of those grandparents and grandchildren, as well as siblings, step siblings, and their spouses or domestic partners, as well as this catch-all of any individual related by blood or affinity whose close association is the equivalent of a family relationship. So this is where you may have long-term opposite sex partners that are living together, boyfriend, girlfriend, and they say, nope, this is my family member and I need to care for them. So that's different than under OFLA and FEMLA. The types of things that would be covered under, for example, OFLA that are not covered would be bereavement leave, the sick child leave, which I kind of refer to colloquially as like this sniffly nose child. So they're excluded from daycare or school because they're not feeling well, but they don't have an actual serious health condition within that definition. And then during the pandemic, we added this daycare and school closures during public health emergency. Again, that's not a covered reason under the Paid Leave Oregon for these insurance benefits, as well as Oregon military family leave. I do want to note though, that there could be a situation where someone's taking OFLA bereavement leave, which could include because of their own mental health issues that they're having as a result of a death in the family. So that may actually also double up as a serious health condition and therefore also be a qualifying event under Paid Oregon leave. So you're going to see a lot of interplay between these different laws and having to analyze exactly what may or may not be covered depending on which law you're looking at. So duration and increments of leave that an employee can take. The duration, they basically start with 12 weeks per benefit year that you can get the Paid Leave Oregon insurance benefits. They add on that it's possible to get an additional 4 weeks in a benefit year of additional unpaid leave that qualifies under OFLA. So they're not getting paid more than those 12 weeks in that situation, but they are able to take additional unpaid protected time off if they're eligible for OFLA within that same benefit year. There's an additional add-on to that, whether they were eligible for OFLA or not. So whether they got the 12 weeks or the 16 weeks under 1 or 2, an employee might qualify for an additional 2 weeks of paid benefits for limitations related to pregnancy. So that could be before the baby's born if they're having some pregnancy disability time off. It could be for the childbirth, or it could be other related medical conditions, including if they're having lactation issues or other kinds of things where they need time off to address those pregnancy and post-pregnancy issues. So this builds quickly where the employees can have a lot of time off. The important thing is looking that for concurrent leave, that if someone's eligible for paid leave Oregon benefits and they are also eligible for either OFLA or FEMLA, those do run concurrently. So it's not stacking in addition to the paid leave Oregon benefits. But that doesn't mean that there may not be times where an employee has time that is eligible under the paid leave Oregon program, and maybe they're not yet eligible under OFLA or FEMLA, because maybe they've worked for the company for fewer than 6 months. So they're not OFLA eligible yet. So there may be times where the paid leave Oregon benefits have already been paid, and then the employee becomes, for example, FEMLA eligible. So there's going to be a lot of interest determining what benefits an employee is able to be taking, or what leave they're able to take it under. For purposes of paid leave Oregon, they define the benefit year basically beginning at the beginning of the work week, which they define as a Sunday through Saturday work week, when they first begin leave for one of the qualifying reasons. So those of you familiar with OFLA and FEMLA would know this as the rolling forward year. So basically, if my first day that I take off is March 1, I then have a benefit year beginning March 1. For a different employee that starts April 15, their benefit year would begin April 15 and follow for the next 12 months. A claimant can't have more than one benefit year at a time. So like that whole 12-month cycle runs before they could start a new one. This is important, especially for employers that are covered by OFLA or FEMLA, that define what their leave year is as something different than the rolling forward year, where now you may have an employee that is eligible or not eligible under the paid leave Oregon, and then now it's running differently under OFLA and FEMLA. For employers that want to make a change to their OFLA FEMLA leave year that they have, to better align with what paid leave Oregon will be using with this rolling forward year, you would need to give employees 60 days notice of that change before implementing it. And then it has to take place in a way that does not penalize an employee to somehow shorten an employee where they are getting less than 12 weeks under OFLA or FEMLA if they were already starting to use that entitlement. So you have to give the employee the benefit of the doubt when you make that change. Increments of leave that the employee can be taking off for paid leave Oregon. The employment department really looks at this in terms of work weeks, but they will pay benefits as little as 1 full work day. But I don't think they actually, I don't think the employee gets the benefit check until they've accumulated a full work week worth of benefits. But for example, you could have an employee that says, I need to have my normal work week is Monday through Friday. I need to have Fridays off for this particular serious health condition reason, for treatment or whatever it is. They would be entitled to get that time off for the full work day, and then they get their benefit check after they've accumulated 5 of those full work days and have a full work week to be paid. So it'll be interesting, so at least we're not talking about like an hour of leave here and an hour of leave there, but still the one work day is still maybe challenging to coordinate with. Looking at other benefits, so we already talked about the fact that OFLA-FEMLA would run concurrently with Paid Leave Oregon if the employee is also eligible for those under those laws. But the Paid Leave Oregon benefits are also, in addition to any Oregon paid sick time that the employer is obligated to provide, any vacation policy that the employer already has, or any other paid leave benefit that the employer offers. The employer may permit an employee to use these other paid leave benefits to bring an employee up to 100% of their, what they refer to as like their average weekly wage. So what I would call their normal weekly wage. This is something that the employer is not required to allow. And you'll see when we get to talking about the payment of benefits that there's some employees that probably under Paid Leave Oregon would be earning 100% anyway under the benefit plan, but others who will be getting less than 100% of their normal wages when they're on this leave. So the employer can decide whether they permit the employee to use their other sick and PTO to cover that delta between whatever they're getting from the state insurance plan up to the 100%. Again, this went back to eligibility, but I note again that an employee is disqualified from receiving Paid Leave Oregon benefits in any week in which they're eligible to receive workers' compensation benefits or unemployment benefits as well. So those are separate programs where the employee can't, quote unquote, double dip. All right, let's talk a little bit about the contributions and the benefits. Each year, OED will set the rate for the following year as to what the contribution rate will be. They've already announced that it'll be 1% combined with the employee and employer portion. And that's on wages up to $132,900 a year. So if you have a high wage earner who earns more than that, you're not paying contributions above that dollar amount. The employment department will, I believe they're expected to announce each September what their contribution rate and the maximum wage amount will be for the following calendar year. What the what wages are that are subject to those contributions, they have very specifically defined in the regulations. So if you have questions about what counts, what doesn't count as wages, I would encourage you to take a look at those or ask questions about that. But you can kind of see some examples of what it includes and what it does not. The employer responsibility is to be paying 40% of that 1%. We'll talk more in a bit about what they call small employers, and those are employers with fewer than 25 employees. Those employers are not required to make the employer portion of the contribution if they do not want to participate. They will, you'll see, still have to deduct the employee contribution, the other 60% of that 1%. And employees, even for those small employers, still will have to be making those contributions. The other exception where the employer does not have to make contributions is if the employer has applied for and submitted a substantially equivalent plan that has then been approved by the Oregon Employment Department. We'll talk a little bit more about what that looks like. But employers will have to be reporting wages and pay contributions. I think they're having a new combined payroll reporting process that will take into account this additional contribution that's going to have to be made on those payroll reports, and with more detailed instructions coming out in the regulations about how that will work for actual payroll administration. The employee contribution is 60% of that 1%, or whatever the rate is set. The 1% is the maximum. So in subsequent years, it won't go up unless the legislature makes a change. The employment department will set the rate, the maximum at 1%. I think the idea is that once the fund has more money, they might be able to set it as a lower contribution rate in subsequent years, but they're going to have to see how it plays out to make sure they have enough funds to be paying the benefits. Employees who primarily work in Oregon, even if they live in another state or occasionally work in another state, still are required to be making the contributions. So those of you who have employees that live up in Washington, but that come work here in Oregon, they have to participate in this. Oregon residents who work entirely in another state. So let's say you have operations where, like, I live in Portland, but all of my work is in Washington. I would not be participating in making those employee contributions here in Oregon. The amount of benefits that the employee will receive when they make a claim really is looking at what the employee's weekly wage is versus what the state average weekly wage may be. I believe those numbers are calculated each year in terms of what is that state average weekly wage. And I believe the last thing I saw for July 1, 2022, and then for that following fiscal year ending June 30th, 2023, that state average weekly wage is just over $1,200 a week. And so it's really looking at what the employee's weekly wage is versus that state average weekly wage. Lower paid employees, which really are those who are earning less than or equal to 65% of that state average weekly wage. So think about $800 a week. When they receive benefits, they're basically going to get 100% wage replacement. Higher paid employees have a formula as to how their benefits are calculated. That they get the 65% of the average state weekly wage plus half of their salary that's above the 65%. So it'll be a sliding scale on that as to how much their wage replacement will be, but it'll be less than 100%. All right, small employers. I've mentioned this a little bit. They define small employers as having fewer than 25 employees. Importantly, they do not use the same way to count the number of employees as OFLA does, which also talks about a 25 employee threshold. So it's not an employer that is covered by OFLA is not necessarily also, not a small employer under this definition, and vice versa. Just because you're not covered by OFLA doesn't mean that you may not be a small employer under this employee count. The number of employees will be determined by your payroll reports, and the department is anticipating notifying employers, basically, this is your size number based on what you've reported. It does include, we're counting bodies, not FTE, so it's full-time, part-time, seasonal. It also includes those out-of-state workers. So if you're an Oregon company and you have 10 employees up in Washington, that counts towards your 25 threshold for these purposes, but not necessarily in other aspects of the program. It does not count, though, if you have an employee that goes out on paid leave Oregon benefits and you hire a temporary employee to be replacing that employee while they're on leave. That person does not count for purposes of this, whether you're at that 25 employees or not. So why does this 25 threshold matter? These small employers are not required to pay the employer contributions. Those who choose to do so will receive grants to help with replacing workers for up to $3,000 per worker, or other wage-related costs such as overtime or training costs to help cover the fact that you have this employee who's out on leave. The maximum number of grants is 10 per year, up to $30,000. But the employer must be able to be eligible for these grants. The employer must commit to paying the employer portion of contributions for at least 2 years. So it's a decision that smaller employers will have to make, whether to participate and whether having the benefits of the grants is something that will be an enticement enough to be making the contributions. Certainly now that we know what how the wages will be calculated in terms of what the contributions will cost, employers that are in this small category can make that calculation and determine, okay, is it worth paying X amount of dollars to be participating in the program and then be eligible for grants. Employers will not have to repay the grants unless their employer size changes. So again, if you're right on that tipping point between up to 25, it may not be, you may decide, okay, do I want to do this or not for the grant, or do I just wait until I have to do it because I'm actually at that tipping point over 25. Right, equivalent plans. I've mentioned those a couple of times. Employers can either enroll in the state's program that I've been talking about, or they can submit an application for approval of an equivalent plan. The equivalent plan really has to look a lot like what the state is providing to employees. It has to be something that's provided to all employees. It can't be select, oh, I do it for my Portland employees, but not my Bend employees. It's sort of an all or nothing that they're covered. It has to be providing equal or greater benefits to employees without having additional conditions or restrictions for employees to be able to use the paid leave. Again, it's looking at that employees can take that paid leave at least one day, one full day increments or consecutively. There's some administrative protections that have to be in the plan, that the benefit decisions have to be in writing. There has to be an appeals process. The employee contribution, if the employer is collecting those contributions under an equivalent plan, it can't be anything more than what's charged under the state plan. And funds collected from employee contributions would have to be held separately from the employer's other operating funds and be used solely for the equivalent plan expenses and benefits that are paid out. There's sort of two different ways an employer could look at having an equivalent plan. One would be to doing their own administered plan, and notably they assume all financial risk if they are doing that plan. The other option is to do a fully insured plan that you purchase from an insurance company to be providing both providing the benefits and administering the benefits. For employers that are looking at doing an equivalent plan, if they want to have it in effect on September 3rd, 2023, when employees can start applying for and using benefits, they must apply by the end of May of next year. Certainly employers could start by participating in the state plan, and then they have deadlines of, well, if we receive the application by this deadline, you have to at least stay in the state plan for a little bit longer until it's approved, and it would be approved effective first day of the calendar quarter following the approval. Approved plans have to be in effect for at least a year, that you have to reapply annually for the first 3 years to continue it. After the 3 years, it's assumed that it continues unless it is terminated either by the state or by the employer. Notice requirements. Mentioned at the beginning that an employer may require written notice of at least 30 days before an employee may begin leave and ask for an explanation of the leave, so they have enough information to understand what leave laws this will qualify under. That's for foreseeable leave. So typically, okay, I'm having a baby. This is the due date. I'm going to give you the information at least 30 days in advance of my due date, and then I need time off for parental leave. If the employee needs foreseeable leave, that could be safe leave. It could be for their serious health condition. It may even be that the baby came early, right? So the leave may begin without that 30 days advance notice if there's that unexpected serious health condition, if there's a premature birth or unexpected adoption or foster placement that comes early, or there's safe leave. But the employee still has to give verbal notice within 24 hours of starting leave, and then provide follow-up written notice within 3 days of starting leave. Importantly, it does not always have to be the employee themselves that's giving that notice. It could be provided by others. I think that the regulations kind of narrow who can actually give that written notice on behalf of the employee that 3 days later, but it's still circumstances where it doesn't always have to be the employee. I mean, as you can imagine, someone who has a serious health condition and is hospitalized may not be able to give notice themselves. In the event that an employee fails to give the notice that is required to their employer, the employer should let the employment department know of that failure to provide notice, and the department can reduce the first weekly benefit amount by up to 25% for the employee's failure to give notice. Employees do have job protections after 90 days of employment. The time off that they take under this program is job protected leave. They do have right to reinstatements back to their same position unless that position no longer exists. The position still exists even if you've hired someone else to fill that position. And so if it no longer, but there are situations where legitimately maybe a department was closed or a store was closed or something where that position really no longer exists. You would then still have to restate employees to an available equivalent position if you are not a small employer. Small employers, though, At their discretion, based on business necessity, must reinstate to a different position with similar job duties with the same benefits and pay. This is going to be really hard, especially on those really small employers, to do without with an employee for potentially up to 16, 18 weeks, and then have to put them back in that same position, regardless of whether they've hired someone else to fill that. Healthcare benefits must be continued during the period of leave. There can be no loss of other employment benefits, such as seniority or pension benefits during the leave. So that looks a lot like OPA and FEMLA. And you can't discriminate against an eligible employee who invokes the law. So there's kind of similar job protections to what we're seeing under other leave laws. Now, temporary employees, and when I say temporary, I'm talking about temporary employees hired to replace an existing employee that took leave under this program. So it's sort of a narrow definition of who a temporary worker is. You are not required to retain that temporary worker after the eligible employee returns to work. But to be able to do that, you need to give them notice at the outset that they are being designated a temporary employee, that it's being used to cover someone who's out on leave, so that you have the ability to terminate their employment on this, and that they're not necessarily eligible for their own benefits under the Paid Leave Oregon under this, and that you can make those adjustments when your original employee is ready to come back to work. Unlawful employment practices, typical of what we see under other Oregon protected leave, is that in addition to reinstatement and other rights that we just discussed, even newly hired employees could assert claims of unlawful employment practice, including for violations of Paid Leave Oregon, denial of leave, or interference with any rights under the Act, or retaliation or discrimination because the employee has inquired about their rights. Employees can either go to court or file a complaint with BOLI if they feel that the employer has violated their Paid Leave Oregon rights. All right, next steps. So employers that are looking to decide whether to apply for an equivalent plan, there's no deadline. It doesn't have to be done right at the beginning, but if you want to not participate in the state plan at all, you would have to get that application in by that May 2023 deadline. Smaller employers should be evaluating whether to be making those employer contributions so that they can be eligible for grants, kind of pencil out the numbers to see whether it makes it worthwhile. All employers need to be looking at their payroll practices to make sure that they're ready to be making those contributions, at least for the employees, and if required for the employer, beginning January 1. OED, like I said, is continuing to push out regulations and finalizing rules, leading all the way up to September. So keep an eye out for those changes, and be ready to provide notice to employees as required by what OED is putting out with their model policy. Those are kind of the key things that we're seeing. I was going to see if I could actually pull and share I'm going to stop sharing and then reshare and see if I can share the website from Paid Leave Oregon. So you can see what kinds of resources they have available. All right, can you see that website page now? Is that coming up? Okay. And so you can see, if you just Google Paid Leave Oregon, this is super easy to find. There's sections for employers. They do have some great FAQs that they have put together to kind of explain equivalent plan, things for tribal governments. Do I have to participate? General questions. So they've got a lot of, smaller employer questions if you're self-employed, equivalent plans, those kinds of things are all up here as resources. There are some links kind of hidden in there to the regulations as they're coming out, and then equivalent plan submission for those who are planning on applying for an equivalent plan. There's details and information on the website about how to do it, what that looks like, where to have questions answered. So I think those are the key things that I had. So I don't know if there are questions.
Yeah, I'll just say thank you very much, Amy. That's there's so much there, and it's going to require a lot of fancy footwork for employers.